Supplementary list, item 31 for pronouncement of judgment.
In the above circumstances, we are of the opinion that the view expressed by the learned single judge in the impugned judgment is one of the possible view. Therefore, we are not inclined to interfere. Hence, this intra-court appeal is dismissed. It is noticed that the proceedings regarding show cause notice issued to the appellants is pending since the year 2021, and therefore we deem it appropriate to direct the authorities concerned to decide the said proceedings expeditiously, preferably within a period of 3 months from today.
Yes. Yes, my lord, may be permitted to mention a matter, my lord, in view of the extreme urgency involved in the matter, my lord. The instant appeal was filed, my lord, just today, my lord. And my learned friend has got the file number, because why the, my lord, extreme urgency is involved in the matter is this, my lord, that the appellant filed an application for impediment or intervention in the writ petitions, my lord. The facts of the case is this, my lord, that the writ petitions was blacklisted in the earlier tender, my lord. In the second tender, my lord, since the petitions was blacklisted, my lord, so the appellant, my lord, emerged as a lowest bidder, my lord. And since, my lord, he challenged the blacklisting, my lord, by filing a writ petitions, my lord, in that particular petitions, my lord, an interim order was passed, my lord, directing, my lord, that the tender should go ahead, authority should go ahead with the tender, but final work order should not be passed. So this is the order. So my right being, since I have emerged as a lowest bidder, my right will be affected, my lord, because this tender process has been stalled, my lord. So I wanted, my lord, to be implemented as a party respondent in the writ petitions, but that was, my lord, rejected on the ground that I was not awarded any tender and the tender was not finalized and no work order was issued. So, but my right was affected because I'm likely to be affected, my lord, because I am the lowest tenderer, my lord, and definitely I'll be immersed as a successful tenderer. So if it is decided otherwise, my lord, then my right will be affected. So I may not be a necessary party, but I must be a proper party. And moreover, my lord, please, tomorrow, my lord, tomorrow matter may be listed tomorrow, because on 26th, my lord, matter, the writ petitions was directed to be posted for hearing. I'm grateful to you, lord.
My lord, with the consent of my appellant, my lord, may I pray for some accommodation in item number 24, my lord, hearing item. My lord. My lord, this matter may kindly be listed on 7th of March, my lord.
Time for the petitioner, my lord. Maybe allowed.
But the request of the concept for the respondent, to this matter on 7th of March.
Obliged, my lord.
Obliged, my lord.
Wait, please, my lord. With the consent of the other side, I would beg to mention item 32 of today's supplementary list, my lord. I seek adjournment for today, my lord. The conducting council is not available.
It is
It's out of state.
listed in the supplemental list.
My lord, item 32, my lord.
32, yeah.
My lord, I seek adjournment for the day, my lord. Conducting council, Mr. Nair is not available, my lord. He's out of station. Another date may kindly be given, my lords.
Last time the matter was fixed while the council has urged that it is very urgent matter. That's why only,
My lord,
yes.
he had to go out of station, my lord. I apologize, man.
Two weeks.
Highly obliged, my lord.
May it please, yes, my lord. With the consent of the other side, my lord, senior counsel for the appeal and this, my lord, I beg to mention item number 25 and 26, my lord. Hearing, my lord. Yesterday, I have circulated the, I told my sleep, my lord. Some accommodation for a week, my lord.
Lordship, I appeal for the appellant lordship. May I put the matter will be taken among court.
Adjourn. With the consent of the parties, matter is adjourned.
Lordship.
Yes.
The please, your lordship.
Right.
Lord, I have filed an IA regarding delay condonation, your lordship. So matter will be listed on next Monday, your lordship.
Tuesday.
Must.
May I please, my lord, with the consent of the appellants, my lord, I beg to mention item number 21, my lord. My lord, I come for the day, my lord.
Adjourn.
May I please?
Obliged.
I am for the appellant, my lord, in item number 21.
Adjourn. You've circulated a slip.
If a date can be given, my lord, on 2nd of April, ma'am.
Whatever date.
Obliged.
Yes.
May I please? I beg to mention item number 27, my lord. Only matter will be adjourned for 27. I have taken consent from the other side.
It's for the other side.
LDA, my lord.
Have you informed?
She is there, my lord.
Have you informed?
Yes, my lord.
Adjourn.
Obliged, my lord.
May it please your lordship. May it please your lordship. With the consent of the other side, I beg to mention item number 30 of the daily list, your lordship.
Item number
30.
30.
Yes, your lordship.
Yes.
Lordship, in this matter, we need some time, we need a week's time to file additional affidavit.
Adjourn.
Lordship, may I please, there's an interim order in this matter, your lordship. There's an interim lordship that may kindly be continued.
Interim order, if I need to continue till next.
Deeply open.
Lordship.
My lord, I beg to mention item number 20. My lord, I beg to mention item number 19 and 20, my lord.
19 and 20.
Yes, my lord, analogous matter. My lord, matter in this case, my lord, I have to file additional affidavit, my lord, in item number 20.
You are for the
I am for the petitioner, my lord. We have taken consent of the other.
State Qualified Elementary Teachers Association.
It's his case, but he has also consented.
Lordship,
Adjourn.
Lordship.
In 20.
May I please, lordship. I beg to mention item number 28, my lord. Herein, my lord, I have to file my affidavit in opposition.
20 is connected to 19.
No, no, 28. 28.
28. Okay, yeah. Adjourn.
My lord, if lordship may kindly fix the matter on 21st of March.
Give the date. Adjourn.
Lordship, like to mention urgent matter for listing on Monday, your lordship. It's a writ appeal.
What's the urgency?
It's a demolition case, your lordship. And actually, the municipal board has issued demolition notices. Now, writ petition got dismissed,
Demolition notices, then how it is maintainable?
your lordship.
How it is maintainable?
The procedure was not followed, your lordship. And we had issued the we had filed a writ petition. Kindly be listed on Monday, your lordship.
Tuesday. Tuesday.
Oblige, your lordship.
Daily list for orders item 1 to 3.
Yes.
The person to, the last order, some
Last
expert,
order, 12th of October 2023.
the matters are being heard, and during course of hearing,
Lordship, in our affidavit, we have suggested so many things which are technical in nature. And Lordship wanted to have some experts so that he can explain the matter before
The
the court.
last occasion.
The experts have come, Lordship.
They are here.
Yes, they are here. They have come.
Last
And
occasion, this district administration Nagaon,
yes,
West Toronto P. Nayak Learning Council ensured presence of the official concerned in the court on the next day to explain the
Lord.
matter in which the authorities plan to deal with the solid waste.
correct, my lord.
Yes.
So, my lord, the experts, they have come and
They
in
have
our,
come, they have come in all
yes, my lord, they have
all
come.
these three petitions or
Yes, my lord, those are taken analogously, my lord. Those are taken analogously.
they are
Ultimately, the
relating to different areas.
relating to different area, well, item number 1, it was originally related to Dibrugarh, but ultimately it was extended, Lordship has extended the scope, my lord, and then now we are considering the entire thing, my lord.
Okay.
So, my lord,
Just a minute, Mr. Ma.
Energy conservation and energy efficiency. Power generation.
Yes.
But as regard the management of the solid waste, my lord, let me explain.
What is your designation?
I'm Ranjit Kalita, Executive Engineer in Directorate of Municipal Administration.
Executive engineer and director.
Directorate of Municipal Administration and also Nodal Officer for Taj Bharat Mission Urban Assam.
You are dealing with all the state of Rajasthan and the state of Assam.
All the state of Assam except Guwahati Municipal Corporation.
Fine. So what is your plan? How to deal with this solid waste and all?
Your Honor, the Ministry of Housing and Urban Affairs under Swachh Bharat Mission, they've allocated amount, the fund for the solid waste management. So including for that we have a PPL detailed project report from the unpaneled agency by the MOHUA, Ministry of Housing and Urban Affairs. And they have prepared the DPR and we have vetted it in institute like Assam Engineering College or IIT. And we approved in the state level technical committee, all the DPS. And then we circulated all the DPS to the concerned urban local bodies and they have floated tenders. Yes. Okay, the 10 days.
What is your exact plan? How to deal with this solid waste? How to use it? Whether there is any byproduct or something? What are your exact plan?
Your Honor, actually, the IEC component is a major part for that. And we have onboarded one IEC agency, that is EVNC, and for this, for segregation at source part. So awareness of the citizens and for capacity building of the ULB officials, etc. So we have onboarded, Directorate of Municipal Administration and Swachh Bharat Mission.
You are planning to set up some plan for that reason or what is the exact your plan?
Yes, Your Honor. Actually, we are going to set up MRF, material recovery facility for dry waste and waste to compost plant for waste, which is kitchen waste. And we are supposed to develop sanitary landfill for the inert waste.
Planning. Finally. Keep on people.
Acha, you're Mr. Kalita, is it?
Yes, Your Honor.
On the last occasion, this court had summoned the officials to understand how exactly is this plant supposed to function and what will be the output. We don't want to know that you will segregate the waste materials, you will collect it, you will put it in a plant, not that. This was because today there are many modern technologies available. This garbage and waste is processed to generate electricity, for example, or many other products which can be recycled and used to put back to use for the society's benefit. So we wanted to know what exactly is the plant about and what is the way you are going to use it. Not that there is fund available or there is a DPR, that we have seen. You have a DPR, you have the fund, you are doing something, but what exactly are you doing? Can you please
Yes.
explain
Your
it to us? What is the DPR about? Can you explain it to us?
Yes. Actually, after collection, in a segregated vehicles for the dry and wet waste. So for the dry waste, we put it in the material recovery facility where it is segregated, and it is all the recyclable materials, all reusable materials are segregated, and some part of the dry plastic waste are collected by rec pickers for recycling and reusing. And the other part, which can be transported to the cement factory, that is transported to Dalmia. We have an MOU with Dalmia, and for this alternate fuel, they are using it as alternate fuel. Because these plastic waste having high calorific value, that is why they are collecting the cement factory. And for the
By
weight
what
waste,
time, but by what time you will start all this process? Yeah, already you have started.
yes, Your Honor, it is some ULB, it has been started, but it is under process. Because MRF are under construction, we are having the plan.
You do one thing, we are not, we will not go into all these nitty-gritties of DPR and all. You file an affidavit, and in brief, what is your exact plan? A to Z, what is your plan? In brief, you please submit a affidavit of this.
And the status?
And the status of what, as per your DPR, how much work is completed and what is left, what is remain to be completed. You just give us a affidavit of this. Okay. So and so, present in person. It has submitted that. Already as per the DPR. Prepared for the purpose of giving the problem of solid waste, the whole state of Assam, except the area of except the area covered under the Guwahati Municipal Corporation. Is further submitted that some work has already been started and completed in pursuant to the said DPR. Whereas some work is still under process and would be completed in the due course of time. Stop having heard Mr. So and so, we deem it appropriate to direct him to direct the concerned official to file an affidavit detailing out the detailing out the exact plan to deal with the waste management in the state of Guwahati. and the status, state of Assam, and the status regarding the present, and the status, and the present status regarding the works completed and under process. When
But Lordship, give us 2 weeks time. 2 weeks time we will give it.
this one 19th of March,
Correct.
19th of March.
19th of March, Lordship. 19th, Lordship. But, on the,
Of the order, Shubham Likhana, in terms of the order dated 12/10/2023 passed by this court, Mr. So and so is present in person. शुरू में ये लिखा है ना
on the next date, now officers are, will be available, or the officers are, will come on the next date, or they will be dispatched at this stage?
the personal presence. The personal presence of the official concern is exempted for the time being.
But,
Item 4.
Yes,
May it please the lordship.
affidavit in reply to on behalf of the petitioner is not received.
We have not filed any affidavit in reply, your lordship.
You are not willing to file it.
Not required, your lordship. In fact, in their affidavit, they have sought some time to give the satellite survey report. What happened, this matter relates to one Madhura River in Kachar district. And because of serious exploitation of stone, minor mineral unit, that is stones, there has been serious degradation of the ecological balance. And way back in 2008, PIL was filed, your lordship.
Yes,
So in that PIL, initially the court called for status report from the deputy commissioner and additional deputy commissioner, and found that there was serious degradation in the environment. And therefore, the court by an order way back in 2015 granted complete ban of any quarrying activities in the Madhura River. However, liberty was granted that the government may file a review. Accordingly, a review was filed. And thereafter, limited quantity of thereafter a committee was formed, expert committee with IIT Guwahati, and they submitted a report. And on the basis of that report, a limited quantity of quarrying was permitted. Now, your lordship, they are issuing tenders in the name of different minor mineral units, but ultimately the extraction is being done from the area which is where there is a ban, your lordship. And therefore, we had approached this honorable court when earlier this e-auction notice was issued. And accordingly, your lordship, they have also issued the order, and one person has already completed. I think the election time has already in the meantime completed.
because on 23rd of May 2023,
Lordship,
in relation to this very PIL, some report was submitted on behalf of the respondents. And it seems that you took time for completing your instructions.
Lordship,
That is on 15/6/2023.
Lordship.
So this report says that A drone survey was conducted along with the Madura River stretchway under the judicial scrutiny. The drone footage clearly shows that there is no mining operations either in Dora Nala or Taikul Nala. Further, it is clarified that no quantity either for the private or government works is allotted and the said two areas, thus there is no scope of mining elsewhere in this pretext in Dora Nala or Taikul Nala. Currently, only government permitted so and so as per the direction of the court. That is, they have submitted the specific report.
Lordship.
May I indicate?
What do you want to say? Yes,
My lord, in fact, my lord, there was an identical PIL file, my lord, wherein, my lord, your lordships have directed, constituted the advocates commission, my lord. The advocates commission visited the place, they gave a report, and the identical PIL has been closed, my lord.
have you that?
Yes, I have a copy of that order.
Have that order?
Yes. And my lord, the
In respect of where is this area?
same area, my lord, same area. And my lord, the area of operation, my lord, it was only for a government, my lord, permit. Same Dora Nala, my lord, and Madura River. If my lord now perishes the prayer, my lord, identical place now.
Yes.
Yes, sir.
The same issue was there.
Same issue, my lord. And my lord, in this area, my lord,
Yes, Mr. Constable. The same issue was there.
I don't know about this one, but from the order, it seems that it is identical to this, your lordship.
This writ petition is filed by the petitioner. The design of public interest petition. Raising a grievance that illegal mining activities slash extraction of stones from Madura River in the name of Taikul Nala are being carried out by the private respondents at the with the connivance of the government officials. Learned counsel for the respondent has invited the attention towards the order passed by this court by a coordinate bench of this court dated 25th of May 2023, wherein this court, by dealing with the while addressing the grievance raised by the petitioners in that petition regarding illegal extraction of stones from small canal slash nala of Madura River by using excavator slash JCB. This court, after taking into consideration the fact that a three-member team set up by this court, constituted by this court, has conducted spot inquiries on 13/2/2020 and 14/2/2020 and has submitted its report that no activity of collection, extraction of stones from the river bank of Madura River is being carried out. Considering the said report, The PIL number 14/2020, raising a similar grievance, was disposed of. Stop. Done it once and for the petitioner is not in position to dispute to dispute the said position. Full stop. This court in PIL number 14/2020 as passed the following order on 25/5/2023. Quote this order. Here, in view of the fact that a similar issue, a similar issue has already been dealt by this court in PIL number 14/2020, which is 20, we are not inclined to pass any order in this PIL. The same is therefore disposed of.
Obliged, Lordship.
Item number 5.
May it please your lordship. Well, this PIL was filed against a violation of a Supreme Court's order where a biodiversity assessment ought to have been done and All India went ahead. We got an injunction. In the meantime, a similar matter was filed in the Supreme Court. And there's an order on 16/3/2023 where since the matter was pending there, the
17/12/21.
seven,
My lord, may kindly peruse 17/12/21 order of your lordship. 17/12/2021. There is an identical case pending before Honorable Supreme Court and Green Tribunal, my lord. 17/12/2021.
Yes. Similar pending before the, it will be, advisable to keep the matter pending.
That case, my lord, before the Supreme Court is again posted on, likely to be posted on 5/4.
5/4. We could get the update.
And in fact, my lord, there were several cases filed before Supreme Court. One was disposed of, sent back to Honorable Green Tribunal. Now the Eastern Zone Green Tribunal is looking after disbursement of compensation.
Well, our case was not on disbursement of compensation. We were on the issue of environmental clearance being done in violation of the Supreme Court's order. We have challenged the notification order.
Concept of the parties that similar matter is pending before the Honorable Supreme Court. In view of the above, we deem it appropriate to adjourn the matter pending awaiting appropriate decision of the Honorable Supreme Court. Just after 5th of April is the next day.
Let it be after 8 weeks, my lord.
This in the month of June 2020.
Well, the interim order passed earlier.
Interim order is pending to continue till next week. What is the interim order?
Well, the interim order was, since we have challenged the EC clearance on the ground that the Supreme Court's order was not in consonance, the injunction was given. The order is of 17/12/2020. Passed by this.
Order is pending to continue till next.
Yes. Okay.
Item 6.
May it please your lordship.
Yes.
Lordship, this matter was for stay of auction of Schedule B property of this petitioner,
Stay.
lordship. Lordship, a loan was taken by the petitioner from the Indian Overseas Bank, lordship, the respondent. Subsequently, lordship, he could not repay the loan because of COVID and all this and that, his business went down. And lordship, his property was slated to be auctioned. Now, lordship, there are two properties in this case, lordship, Schedule A property and Schedule B property. Schedule A property was auctioned off at 3.76 crores. And the total loan at that time was, lordship,
Excess amount of around 2 crore is there.
yes, lordship. So lordship, subsequently, when they went to take physical possession, lordship, some anomalies were found. And lordship, the sale could not be, proceeded with. So lordship, what they tried to auction the Schedule B property. But lordship, the main thing here is in So Lordship, the anomalies were regarding a building, a structure. The structure was GCC, RCC, G+2 building. The land remains the same, Lordship. Subsequently, Lordship, on physical verification, what it was found that instead of the RCC building, there is a Assam type building. But the measurement of the land, it's and the dark number, pattern number, all are the same. And subsequently, Lordship, they have cancelled the sale and they have issued e-auction notice, a fresh e-auction notice. But Lordship, herein, if I may direct your attention to Lordship, page 67 of our petition, Lordship. It's the valuation report as on 30/11/2021. Lordship, herein the value of land is 4 crore 25 lakhs. Only the land. I'm not talking about the building, Lordship. The value of the building is 71,82,000. So, Lordship, our main prayer at that time was that if the need be, then the first Schedule A property that may be auctioned off because the Schedule B property is of a lesser value. It's below 1 crore. So, Lordship, there was no need to auction off both the properties. If subsequently, Lordship, they could not, repay the loan, then the Schedule B property may be auctioned off. Lordship, in the affidavit, Lordship. The reserve price has been fixed at rupees 2 crore
No, it
60.
may be, Mr. This annexure C is under challenge.
Yes, Lord.
The auction notice.
No. So what has happened in this case, this court by the order dated 13/10/2023 directed us not to proceed with the auction for the Schedule B property. Because at that stage, the Schedule A property was already sold. During the process of taking the physical position, certain anomaly was found in the boundary, that was subject to change. So, first we had to forgo the auction, cancel the auction of Schedule A. Now, because of the failure of the auction of Schedule A property, we had to refund the entire auction money to the auction purchaser. Because as of today, the outstanding in the account is about 1 crore 70 lakhs. If he says that I should not proceed with Schedule, we cannot predict which auction will be successful. That cannot be done. Either he brings a buyer for who is willing to pay 4 crore rupees, where we will be very happy.
Ultimately, is agreed by this auction notice.
Yes, he did not, he was not against the auction notice.
This annexure C is what base
This
98.
annexure C that we have filed is page 98, that is the fresh auction notice.
Fresh auction notice.
Yes, in respect of the Schedule A property, which auction was cancelled. After this,
Earlier.
yes. So this court, on 13/10/2023 directed that since you have already sold the Schedule A property, so don't proceed with the sale of the
But
schedule. That situation has now changed. Yes.
Mr. Whatever it may be, if you are having any grievance, approach the DA.
Lordship.
Approach the DA.
Lordship.
Withdraw it and have liberty to approach the DRT. That's all.
As such, Lordship, we are not challenging the auction, Lordship. We are just stating that
Whatever it may be, you are this auction notice that is dated in pursuant to section 13(4).
yes, Lordship.
Yes, you whatever the proceedings that the financial institution carrying out pursuant to the Securitization Act, you approach the DRT.
Lordship.
Okay. Then consequent that he submitted that he does on instructions has submitted that he does not want to press his petition award takes liberty from the petitioner to approach the DRT under section 17 of this Act of 2020, 2002. Stop. Dismiss with liberty as prayed for.
The interim order stands vacated.
Automatically, if the writ petition is dismissed, interim order remain in currency.
Item 7.
But it's a similar appeal.
Similar matter.
It's a similar appeal. Lordship has admitted.
Similar order.
Lordship.
Is that order will pass the same order?
Yes, sir, I have done.
Same order.
But I But we have also a prayer for in stay of the judgment, my lord. It is stayed already in the other case, my lord. Lordship, my lord.
You have not passed any order in the
Lord.
other appeals.
Lordship.
Since it is already
Correct.
stayed.
Correct, correct.
Yes.
Item 8 to 12.
May I please, your lordship? Lordship, item number 8, 10, and 12, lordship, kindly adjourn for a day. The engaged council is out of station, lordship.
8, 9, 10, 11, 12. All are connected matters.
Emergency is there on our part, my lord. Date will be given in the next week, my lord.
Urgency to the respondent.
Yes, in one case, I'm the respondent, in connected case, I'm the petitioner also, my lord.
So any stage operating against you.
Stay is vacated by but after that, my lord, the process is not.
Next week.
Item 13.
And in this case, last occasions, the respondents taken time to file their affidavit.
Here we have received our instruction, Lordship. I'm seeking 2 weeks accommodation to file our affidavit, Lordship. We have just received the instruction, Lordship.
I'll pray for a fixed date, my lord, in that.
Just on so and so.
First one, like, first one, like, petitions.
Yes.
Item 14.
Wait, please, Your Lordship. Your Lordship, the subject matter of this PL is to change the character of the heel sticker, Your Lordship. Heel being holographic excise adhesive label, Your Lordship. Now, the sticker is used by the excise department to curb illicit liquor and also to identify each and every genuine IMFL bottles, Your Lordship. Now, in the state of Assam, the character of the heel sticker is of plastic, Your Lordship. And on the other states like Orissa and Maharashtra, they are using paper, Your Lordship.
And in this matter, we received the instruction, Lordship. We'd like to file an affidavit, Lordship.
In the last occasion also you are granted time.
Yes, Sir, Lordship. We have recently received the parawise comment, Lordship. We'd like real affidavit on this matter,
What
Lordship.
are you contemplating to use this paper stickers or the plastic stickers?
Because this stickers which we put in the bottles, they are multi-layer film, Your Lordship. We are the he's containing using plastic, but we are using multi-layer film. That's it, and that's exempted in the notification which you have annexed in the PI, Your Lordship.
That but multi-layer filling is
Exempted, Your
in that
Lordship.
notification.
No, you know, in the notification
And
itself.
if they're contingent, let them file their affidavit. Consider it. Okay, Mr. So. Please for granted. For the time to file reply, counter to the petition, list on so and so. It will be dated.
Obliged, Lord.
Item 15.
Last occasion, your lordship asked me to, my lord, what is the result on seal cover, my lord? That is one.
Good morning, Lordship.
Yes.
I produced the statement of the marks of the candidate still form.
Result to Pavilion.
And fail to secure 60%.
Qualifying marks, your lordship. If I have not secured qualifying marks, then your lordship, there is no case.
The petitioner, comma, a
Qualifying marks
PWBD
before then.
in bracket
No.
person
Written.
with benchmark disability, bracket close, line candidate has filed this petition under Article 226 of the Constitution of India. Raising a grievance that the respondents have not granted him opportunity the respondents have illegally not considered the candidature of the petitioner, though though he received though he scored higher than the minimum pass marks in the mains written examination for the Assam Judicial Service Grade 3 examination 2023. Full stop. Pursuant to the direction given by this court, the petitioner was allowed to appear in the
Main exam. Main exam. my lord. Earlier one is prelims.
The petitioner, a PWBD person with the benchmark disability blind candidate has filed this petition, raising a grievance that the respondents have illegally not provided any reservation for the PWBD category in the in the Assam Judicial Grade Third Examination 2023. Full stop. This court, wider order dated 1/8/2023, has allowed the petitioner to appear in the mains examination of the Assam Judicial Service Grade 3 Examination 2023. However, it is clarified that the result of the said main examination shall not be declared without the leave of the court. Full stop. Later on, the said interim order was modified and modified by the order dated 3/10/2023, and the respondent Guwahati High Court was permitted to proceed with the selection process for 17 out of the 18 unreserved category unreserved category of posts and other reserved category posts, and with the further direction that one post in the unreserved category shall be kept vacant till the next day. Full stop. Meanwhile, the mains examination, the result of the mains examination has been declared. However, pursuant to the direction passed by this court in the interim order, the result of the petitioner has not been declared. Full stop. This court by order dated 20th of February 2024 directed the respondent High Court to produce the result of the petitioner in sealed cover. Result of the petitioner of main written examination in sealed cover. Full stop. Today, the result is produced before us, and as per the same, the petitioner has failed to secure 60% in aggregate in paper number first, second, third, and fourth, in accordance with the Rule 3A of Schedule B of Assam Judicial Rules 2023, 2003. Stop. In view of the fact that the petitioner has failed to clear the main written examination, we are of the view that no further relief can be granted. No relief can be granted to the petitioner in this writ petition. The same is therefore dismissed.
All the interim order.
Already interim order is.
Yes,
already
it's merged with the final order.
execute हो गया.
The miscase also disposed.
Interim order passed by this court is hereby vacated.
Mr. Bothagur, have you seen the 19th of February notification? This is a notification of the government.
Now it
The client would have been out even if
even it is lost.
Since post is identified, then your we don't have it. Deeply obliged.
The result of the record produced by the High Court be done to it. Yes.
Supplementary list, item 33.
May it please the Lordship. My Lord, what had happened, Assam Police Housing Board, recently they introduced this, my Lord, concept of EPC contracts, engineering, procurement, and construction. My lord, earlier practice was the design and engineering part was done by the corporation and procurement and my lord, construction was, left out to the contractors. Now, having regard to the new, my lord, policy, they issued an tender for 16 projects, each of 7 crore and odd. Now, my lord, we otherwise qualify the technical criteria, but my lord, we do not qualify in the experience criteria. Now, my lord, the government of Assam in the Public Works Department, which is a very much more bigger department than this Police Housing Corporation, even they have introduced EPC without the experience clause. Now, as a result, what happened, my lord, we could not participate. Now, in effect, what we notice is out of the 16 projects, there were bidders for only 12 projects. And in respect of the 12 projects, my lord, work order has been issued. So, my lord,
Yes.
so, my lord, the 4 are left. And post this tender on 15th to 15th, no?
15th of April.
15th of February, my lord, Assam Housing Corporation, Police Housing Corporation has issued another NIT for about 150 odd projects where, my lord, they are not insisting on the experience part. So my only humble submission, my lord, without going into the merits, regarding that 4 package for which there were no bidder, my lord, let them consider, my lord, whether without experience that can be done, as they have done now.
Representation with the field, so they'll consider it.
No, my
How
lord.
can the court can give a direction?
And what I'm saying is, my lord, also will kindly see, end of the day, my lord, let us have that even level playing field.
Level playing field, sir.
No, I know, my lord, strictly it may not be in the realm, but only all that I'm praying for is let them consider our prayer, my lord. Only that much. That experience part, PWD has relaxed. Here they have not done. As a result, for the 4 projects, there were no takers.
But out of how many members are in your association?
No, sir.
How many members are there in your association?
Substantial, my lord.
Substantial out of them, some of the members have participated in the bidding process.
My lord, 3 participated, 2 are out.
Only 2 are out.
Yes.
3 persons have participated.
My lord,
They are
kindly
taking
see,
the
in a
criteria.
16 project tender, there were no bidders for 4 projects. Well, I am not trying to assert any right as such, my lord. Let them only consider.
Yes, Mr.
My lord,
Let them submit a representation.
And they will consider, as they have done on
Accordance
15th
with
February.
law.
Considered
Strictly in
Yeah.
accordance with law.
my lord.
My lord, we have got
Without-
300,
without expressing
I'm
any-
sorry, we have got 300 members, my lord, got the info.
Yes,
Without expressing on the merit of that,
Of course.
not at all.
my lord,
He is withdrawing in fact.
my lord.
He is withdrawing with liberty.
Yes,
We
Well-
grant him liberty, that's all.
and they will
Strictly on the-
consider.
Strictly on the basis of the, my lord.
They will consider without being influenced by any observation made. So what is the observation very well? Respect of rejection. The representation has to be considered without being influenced by the observations of the learned single judge.
Yes,
Otherwise, there is no
Yes,
purpose
yes.
of this exercise.
yes.
My lord.
And in fact, on 15 to 24, they have come up with tender for 150 projects where they are not insisting on experience.
But in fact, my lord, I represent only, my lord, response number 1 and 2.
Representation.
Therefore, and then-
Which is this authority was issued the bid document?
My lord,
Which is
Assam
the
Police.
authority which has issued this bid document?
yes, Assam
Assam-
Police Housing Corporation.
Only difficulty is, my lord, I am not representing the Assam Police Housing Corporation. I represent the government respondent only. Only respondent number 1 and 2, my lord.
Who was representing the Assam, this?
There is no standing council, my lord.
You are representing them
I represent only, my lord, government respondent 1 and 2.
before the learned single judge who represented the.
Because, my lord, AG was appeared, AG was engaged.
Police Housing Kora, he does.
My lord, my learned friend is.
Yeah, representation is present there.
Without expressing any.
Yeah, no.
Relax, relax.
Yes.
My learned friend appears.
For the corporation.
You are appealing for the corporation?
Lord, in the meantime, my lord, orders were issued to the successful bidder.
Yes, sir, that was.
In the meantime, successful bidders, order, work orders were issued.
Already issued.
We are simply saying he is withdrawing the petition while contending that a similar condition of this
Experience.
was incorporated in the bid document of the PWD, but later on it was relaxed and in such
No,
circumstances.
no, my lord. PWD never insisted, they have relaxed now. PWD never insisted on the experience. They have come up with an EPC contract without insisting on experience. And they, my lord, Police Housing Corporation on 15/2/24 has issued an NIT for 40 projects where they are not insisting on experience.
Subsequent NIT.
Yes, subsequent. And only in respect of 4, my lord, left out packages. Covered by NIT dated.
This intra-court appeal is filed by the appellant being agreed with the order dated. Appellant agreed by the order dated 15, the judgment dated 19/1/2024, whereby the writ petition filed by the appellants challenging the additional qualification regarding the experience as mentioned in clause 2.2.2.4 in the bid document issued by the Assam Police Housing Corporation Limited. Full stop. The learned single judge but has been dismissed therein for take full stop. Then the concept of the appellant has submitted that earlier the PWD department has not insisted for the additional qualification regarding the experience from the eligible contractors. And later on, the Assam Housing Corporation,
Police housing.
Police Housing Corporation Limited has also issued an NIP wherein the condition of additional, where is the condition of additional qualification regarding the experience has not been incorporated.
EPC board.
That is 15 to 24, my lord.
EPC mode.
EPC mode,
EPC mode.
EPC mode, experience EPC mode, full stop. The net counsel for the appellant submitted that in view of the subsequent development, the appellant wants to withdraw this appeal with liberty to file a representation before the representation to the Assam Police Housing Corporation with the prayer to relax the condition of experience on EPC mode in respect of, in regard to the
Four package.
four contracts,
Four packages.
four
Package.
packages for which no bids were filed by any contractor. Full stop. The net counsel for the state as well as the State Housing Corporation has no objection if, while granting permission to the appellant to withdraw the appeal, the said liberty is granted. Full stop. In view of the above, this writ appeal is dismissed as withdrawn with liberty to the appellants to move appropriate representation with a prayer for relaxing the condition of additional criteria as mentioned in clause number 2.2.2.4 of the bid document in question in respect of the four packages wherein no bid is filed on behalf of any contractor. Full stop. It is expected that if any such representation is filed on behalf of the appellants, the Assam Police Housing Corporation Limited shall consider the same objectively, consider the same expeditiously and objectively.
Without being, my lord.
जरूरत नहीं होगी ऑब्जेक्टिवली ना दे
Deep knowledge.
Item 34.
May I please your lordships? My lord, this appeal, instant appeal has been preferred in respect of order dated 6/2/2024, which has been passed ex parte against the writ appellant, my lord. My lord, in the writ proceeding, my lord, the notice of the writ proceeding has not been served upon the appellant, my lord. The appellant is the settlement holder of a market, my lord. So while he was running the market, my lord, the writ petitioner, my lord, approached before this honorable court, inter alia.
The notes, they filed an affidavit regarding service of notice upon you.
My lord, that dusty service notice has been filed stating that
Deemed. Repetition report to us in here. Repetition. It is section A order to finally 4/12/2023 passed in WPC number 4432 of 2023 Order date of 4/12/2023. Merit is application. You look at the. In the. Would be the. Then in the paper. After that, I will. It will be sorry. Indicate them. आगे बढ़ते हैं। मेरा ही रहता है। कोई सा भी ये सब देखने में follow करते हैं। बीच में से देखते हैं, पर करते हैं। तो इसमें से तीन ये डिपेंड दो है ये इसके रिस्क है ये ज्यादा ज्यादा होगा फिर देना पड़ेगा पहले इससे ज्यादा होगा तो that's what मेरा ही इम्पोर्टेंट एक्टिविटी आज ये इसका एक ही recommendation
So your main grievance is that notices were not served upon you.
Yes, my lord.
What do you want to say on merits?
And on merits, my lord, if your lordship comes to my notes at page 27, my lord, it says that the writ petitioner, my lord, who was the third highest bidder, my lord, his rate has not been approved, not because of the high rate, my lord, because he did not submit the bank draft, my lord, in the manner provided in the tender notice, my lord. Because he quoted an amount 11 lakh something rupees, out of which the demand draft has been submitted for only 10 lakh something, and rest of the amount he has submitted by way of banker check, my lord. And because of that reason, my lord, the minutes and comparative statement at page 26, it reflects, my lord, page 26, my lord.
Yes, read.
Page 26, my lord, comparative statement, my lord.
Yes.
Number 3 is the writ petitioner, my lord, Baburam Brahmo. So on the remarks column, my lord, banker check and original Bakidai clearance certificate not submitted. So therefore, the response number, the serial number 4, my lord, the writ appeal has writ appellant has been approved, my lord. Because, my lord, in the tender notice, my lord, as per clause 5, my
तो उन्होंने ये नहीं किया उसको देने के लिए नहीं मार्केट
I am for official respondent, 1 to 4 BTC.
Notice, in concept of the, will accept notice, in concept of the, Ms. So accept notice on behalf of the respondent number 1 to 4. Let notice be issued to the respondent.
Number 5.
Number 5, returnable on 7th of, 11th of March. 11th of March. Thus the, in the meantime, effect and operation of the order dated 6/2/2024 passed by the learned single judge in WPC number 4432/2023 shall remain state.
Lordship, in this regard, for modification of order of this, Lordship, I have also filed one IA in.
Modification of order by the learned single judge.
Yes, IA for modification for a correction of the correction of a.
That application is to be considered by the single bench, not by this.
That has been disposed of, Lordship, corrected, Lordship. In the state order, Lordship.
You want correction of what? Single judges order?
Already corrected, Lordship. Can you produce the order?
Bring it on record.
Lordship.
Respondent number 5.
Step in 3 days.
My lord, 11 March, my lord, I have some problems. Can it be on 13th, my lord?
13.
Deeply obliged, my lord.
Deeply obliged.
Daily list, item 16 to 18 for final disposal and admission stills.
Bengal Public Demand Recovery Act. এই হেৰি এখন দিবচোন লেবাৰ ইণ্ডাষ্ট্ৰিয়েল ট্ৰাইব্যুনেল 1955. So they are disputing the amount.
Yes, no, my lord. Why, your lordships, the division bench, the earlier, the Honorable Chief Justice Sandeep Mehta, my lord, while deliberating, while the argument was heard, decided to call for the records. Decided to call for the records. Why, my lord, the records to be called? Because the act which just now I have handed over, the working journalist and other newspaper, kindly see section 17. For that reason, the records were called for. 17 of the act. My lord, just I'll place it so it become easier for connecting the entire issue. Very nutshell, I'll just tell it, my lord. We had a newspaper house, my lord, but we closed down in 2018. Prior to 2018, 2016, the Assistant Labour Commission issued a notice to us saying that some arrears salary were due to the employees. Please pay it. But there was no statement which was not enclosed. Subsequently, we replied. Subsequently, in the year 2018, 17, we received a notice along with notice of warrant of arrest, whereby Labour Commissioner, my lord, forwarded to the certificate officer for realization of 1 crore 82 lakhs, which is due to the employees. Under the Majitia Wage Board recommendation that was sent to us. Now, this notice was put to challenge before this under single judge on two grounds. First, no notice was served, and there is a violation of 17 of the working journal, which I have just handed over to your lordship. There is a violation of 17. Why there is a violation of 17? One is we have not received notice. 17, my lord, suppose there is a due to the employees, to the employee, and we have not paid. So there can be an application which can be filed by the employee to the appropriate state government. That's what we argued, the appropriate state government. Now the appropriate state government is under the rules which I have handed over. That rule says under Rule 36 Form C, you have to file before the appropriate state government, meaning thereby under Form C, Rule 36 is the secretary to the Labour Department assigned. Now, we placed it before the court and we said that there is no application has been filed.
And once the application is filed, then there has to be a subjective satisfaction of the appropriate authority. Now, subjective satisfaction, what we pointed out before the court, some notice has to be issued to us. So we can give a reply to them. Once we give a reply, then the authority concerned can pass a reason order. Either I admit or either I dispute. In this case, no notice, straight away the labor commissioner sends it to the Bakizai for recovery of the amount. Now, in this context, the court said, we wanted to see the records and find it out, number one, whether there is anything about regarding serving of notice to you or not. And what is a subjective satisfaction that is where I am.
Who moved under 17(1). मैं कहता है कि ये अफसर Have you got the records, Mr. Sharma? Yes, sir. Order of Labor Commissioner is there. Can you please flag it?
My lord, one thing before your lordship looks to record, if your lordship permits, one thing I just want to submit before your lordship. Your lordship has read 17(1) and learned single judge under 17(2) has referred the matter to Labor Court. But while deliberating the matter before the learned single judge, on the first point regarding notice, a writ petition which was filed, on the basis of the notice, and we said 17 has not been complied. Now your lordship has read 17. Now, coupled with 17, kindly see the rules 36 because your lordship is looking the records. Because during deliberation for learned single judge, we took the plea of 17(1). It is not before the appropriate state authority because this has to be in accordance with the rules. So rule 36, if your lordship I have handed over, form C, kindly see rule. For a moment, kindly see 36, my lord. See rule 36.
application under section 17 of that.
Right, that's everything. So an application under section 17 of the Act shall be made in Form C to the government of the state where the central office or the branch office or newspaper established in which the newspaper employees employed. So if you see Form C, kindly see Form C to the secretary to the government of Assam. So and so department, so and so which deal with labor matters. Now during deliberation, we pointed out 36. The court has directed the government to produce the records. See that whoever the notification issued by whom? Notification. Now they brought during the course of hearing notification, the labor commissioner, they have subdelegated the power to labor commission. Now we challenge that by way of a notification. That notification was put to challenge. And power has been delegated under 36. How can you subdelegate it? That's what we challenge it. There was some interim order passed. Both the matters was taken up by the learned single judge. Now, this judgment is before your lordship. The learned single says, what is notification? That notification, subdelegation, ultimately, it has by state government, labor commissioner comes into. So that point was negated. But so far as the first case is concerned, partially it was allowed. On the ground that what we find that it's a question of dispute. So under 17(2), we'll send it to labor court. Let it for adjudication of the matter.
Yes, satisfactory and getting.
Yes,
Mr. Sharma, you flagged the order of the labor commissioner.
Small file in the top, my lord.
This one.
In fact, my lord, as per the direction of the Honorable Court on the earlier occasion, would the parties.
We were directed, my lord, by the Honorable Chief Justice to inspect the records, both the parties. So accordingly, they have inspected the records. And I have found one thing, my lord, by inspection, the subject to your lordship has to look into it. I found one thing in 17, my lord. If your lordship, I have trouble your lordship with 17. Kindly look into 17. Where any amount is due under this act to a newspaper employee from an employer, comma, the newspaper employee himself or any person authorized by him writing in this behalf. I'll pause for a moment. Here, they doesn't directly comes. They comes through an union. That's why, sorry, man.
Anyway, what amount?
Something about 1 to 82 lakhs.
82 lakhs.
And that's they relied. I have checked, my lord. They relied. Closure notice was challenged. And a lawyer prepared that. And on the basis of that preparation, they said 1 to 82 was due.
Whatever it may be, but ultimately, whatever it may be, some amount is.
Yes,
due.
yes. My lord, I
Some amount is
can't.
due. Then ultimately, the learned single judge is only given direction to that matter be referred to the.
No,
labor
only
court.
the,
The labor
absolutely.
court will adjudicate it and thereafter.
My lord, I don't disagree. the problem here is why I came up an amount of 25 lakhs to be deposited.
That's the.
Now the learned the division bench said that I said that my newspaper house is closed down. So 15 lakhs to be deposited before the register. So on the subject to condition, so we deposited. My lord, it's a fact, my lord. It has to be decided. The issue has to be decided by that authority. Only I am aggrieved that the amount. No, let it be decided. I don't mind. It may go against me, it may go in favor, that's absolutely no problem. But that amount cannot be put in with great respect by the learned single judge. That's what I am on, my lord.
That has already been stated.
Yes, this order has been stated, subject to condition 15 lakhs to the registrar I have to deposit. No, a lot of things I can argue, but I understand, my lord. Some employees, they are entitled. But I can argue on the point that where is the authorization? The foundation wherein, I know, I understand.
And it has to be adjudicated. The learned single judge referred the matter to the.
Correct, my lord, right,
So far
absolutely.
as regarding this 25 lakhs, iska kya कहना है आपको?
Lordship, so far as this case is concerned, your lordship, in fact, your lordship, we are agreeable to the honorable single judge judgment. For reference, your lordship, the matter today, and that 25 lakhs, your lordship, out of 1 crore, your lordship, something, your lordship, your lordship will kindly note one aspect, your lordship. From 2011, they are not getting their, your lordship, areas, your lordship, as per Majitia West Board, your lordship. So 25 lakhs.
Without there being any determination, how the court can come to the conclusion 25 lakhs, then why not 1 crore?
1 crore, your lordship, since your lordship, entire amount is, if it's allowed to deposit, your lordship, then your lordship.
Deposit and disperse.
And that is why, your lordship, we have put this order of the honorable single judge to challenge, your lordship. We have also filed an writ appeal, your lordship.
Why raising what grievance?
Lordship, our grievance is that, your lordship, two things, your lordship. First of all, your lordship, the argument of the learned senior counsel, your lordship, is that they have not been put to notice while, your lordship, that is actually not the fact, your lordship. I can show, your lordship, at least only 3 documents which will show that
Who has determined that due amount and how he has determined?
Lordship,
this 1 crore 82 lakhs or whatever the odd figure, I has come to the conclusion that that this much of amount is due.
if your lordship takes up my appeal, your lordship, that is at page 347 of 2000.
From the record, it is only this, some application was moved. Payment of Senator Majita Wade Board recommendation notified also directed by in enclosing here with the statement of area of as per recommendation of Majita Wade Board of your employees appointed as working journalists, including administrative and factory staff, and I am to request you to pay the area wages within 15 days, submit a report of compliance accordingly. Where is the determination?
Lordship will kindly see one aspect, your lordship. For determination, they will have to raise a dispute under section 70.
Ultimately, at least for any, you move an application, I owe this 25 crore rupees and I am required, he is required to pay me. And the commissioner will pass an order, okay, pay 25 lakhs.
Lordship will kindly see, your lordship, only 3 documents, your lordship. I will show your lordship. If they are after your lordship is not satisfied, your lordship will kindly come to page 66 of my appeal, your lordship. That is 347 of 2022. Only 3 documents, your lordship. In fact, what has happened, your lordship, in this case, there is a, your lordship, after recommendation made by the Madhya West Board, your lordship, that was put to challenge by a particular newspaper group, your.
Yes.
Newspaper group, your lordship.
Yes, which document?
Page 65, your lordship. Of my writ appeal, your lordship.
What is it?
Yes, your lordship will kindly see. This is from the Labor Commissioner to all the newspaper owners, your lordship.
Yes.
Page serial number 20, Jano Sadharan. The appellant in the other 2 cases, your lordship.
Yes.
then your lordship may kindly see the letter. Implementation of the recommendation of the Maziccia West Board. Now, your lordship, first paragraph, we are leaving second paragraph. All the journalists and non-journalist unions are requested to submit the detailed ADR claims of all the journalists and non-journalist employees working in different newspaper establishment to the Labor Commissioner so that the Commissionerate can make arrangement for recovering the dues to earliest in case newspaper establishment do not comply with the order of the Honorable Supreme Court of India in regard to implementation of the recommendation of the Maziccia West Board Award. This Commissionerate will be bound to take action as per the provisions laid down in Working Journalists and Other Newspaper Employees Provision Act 1955. Thereafter, your lordship will kindly come to page 40, your lordship. This was dated 6th February 2016. Then your lordship may kindly come to page 40 of my petition. We submitted our claims, your lordship, and your lordship, this is a letter written by the Assistant Labor Commissioner to the General Manager, Janasharan Printing and Publishing Private Limited. Payment of arrear salary as per Maziccia West Board recommendation as notified and also as directed by the Honorable Supreme Court. In enclosing here with a statement of arrear of salary as per the recommendation of Maziccia West Board of your employees.
Mr. Concept, tell us,
Lordship.
but you tell me before
Lordship.
they have submitted, why there this 16th or 6th of February 2016, you requested them to submit your claims.
Lordship.
They have submitted the.
We submitted, your lordship.
Then at least the only requirement and the least is, at least you should have issued a notice to MK that this much of recovery amount, they have, that this much of arrears they are claiming. What do you want to say about it? At least either he can dispute it, either he can admit it. Where is the, then, this principle of natural justice, the least demand is that at least give him a notice, this much of the due is there. How otherwise he is going to be satisfied?
Lordship may kindly come to page 94. That's why I am saying that your lordship, only 3 documents, your lordship.
94.
94, your lordship. This is a, your lordship, minutes of the tripartite committee formed for implementation of the recommendation of the Maziccia West Board in the state of Assam.
Yes.
This was dated 24, 2017. Now, your lordship will kindly see second point, your lordship. First part I am leaving, your lordship. He further informed that the implementation of the recommendation of the Maziccia West Board Award is directly monitored by the Honorable Supreme Court on 23rd day of every month. The Honorable Supreme Court reviews the status progress of its implementation statewide, and most probably the Labor Commissioner Assam will soon be called upon to explain the status in Assam. The Honorable Minister Labor and Welfare Chairman then requested the management representatives to give their views, objections, suggesting regarding Maziccia West Board award implementation, area calculation, etc. to the committee. In response, management of Janasharan said that they have no objection in the calculation done in estimating the arrears due. None of the other newspaper management present in the meeting raised any issue with this regard. Now, this was their statement in the tripartite meeting, your lordship. That means, your lordship, they have the calculation before then, your lordship, when this tripartite meeting is held. Then where is the question of raising a dispute, your lordship? They did not raise any dispute at any point of time. Your lordship will kindly note, even when the notice was issued by the Bakija officer, your lordship, under section 9 of Bengal Recovery of Demands Act, your lordship, they are required to submit an explanation, reply to this purpose. They remain silent and also, your lordship. Now, once you admitted that we have no claim against the calculation made, only in the writ petition they have for the first time raised this dispute, your lordship. It's very clear, your lordship, from the minutes of the tripartite meeting, your lordship.
This order, earlier order at page 90 pertains to the same group.
Lordship.
Page 90, there is the order, earlier order passed by writ court.
Same group, your lordship. That is not regarding area, your lordship. That is regarding salary. This is your lordship question of area came, your lordship, when the after Mazithia West Board recommendation, Honorable Apex Court stayed it. And when your lordship ultimately stays vacated, your lordship, the question of payment of area came into.
Mr. Bhattakar,
Lordship.
these are matters which are covered by provisions of the statute.
Lordship.
The question is not whether your clients should get X amount of money or not.
Lordship.
The only thing we will examine is whatever method has been chosen here, is it in accordance with the statute?
Lordship.
If not, whatever is the correct procedure will have to be followed.
Lordship, lordship.
So this court is not going to get into what amount is due, how much your clients will get, etc., etc. If you don't take the correct course, then no matter how far you go, you will go back to zero.
Lordship.
So there are courts after
Absolutely,
courts
your
after
lordship, what
courts.
is fallen from your
So
lordship.
Please address the court on that issue.
Lordship.
Getting an order here and there is not going to help.
That is, now you see this page 40
Lordship.
is the direction by this labor commissioner or whatever the labor commissioner to pay so and so amount.
Lordship.
And this now page 94, what you are referring to,
Lordship.
it speaks about the same calculation which the labor commissioner has said or something else.
Same.
Which calculation?
Same, your lordship. Area, your lordship. It relates to area.
But no clarity on this. In the response to management, so they have no objection. Calculation estimate areas true.
I am, your lordship, humbly submitting, your lordship. I have no objection, your lordship, that if the matter is remanded back to the labor or the court to decide the matter, your lordship. But my only concern is, your lordship, for long period of time, these people, your lordship, workmen are without any salary, etc. This 25 lakhs, your lordship, even paid to them, it will be a paltry amount, your lordship, to which they are entitled. That may be, your lordship, paid to them. Only that amount, your lordship. My. Some of these people, your lordship.
So
do not
Mr.
have-
Das, they are entitled to some amount. The
So
amount
15
can
lakhs,
vary.
no, my lord, 15 lakhs has been deposited before the registry.
No.
15 lakhs, 15 lakhs. So that lakh, my lord, that should be, let the labor court decide as expediency as possible. Within 4 months can be decided.
But suppose this 1,82 crore or whatever it may be on demand, you are disputing that.
Yes.
How much money is due against, due with you? At least you come out with a figure.
Let them give the figure.
You come out with a figure.
Yes.
Admitted amount.
Admitted, which you are admitting. Come out with it.
We have, So, what we can do it, my lord, or my learned friend is saying this certain amount, we'll have a settlement. Let us discuss outside the court regarding about the issue. If it is they agree to it, then we can settle this issue, my lord, here itself.
Mediation with them.
Only this 25 lakhs.
Let's, my lord.
Come out with a figure or whatever you want. Have your mediation in between the advocates.
Yes. No,
Whatever, otherwise, if money is due and you are also admitting that, yes, money is
I
due,
can't,
you are also not disputing
my
that.
lord, I am in this court for so many, I can't say that it is not due. How can I say it is not a due, my lord?
Come out with a
Some
figure.
amount, yes. Some, what is the amount? Your lordship wants to know the figure. What's the amount? That's
As
all.
per you.
Yes,
As
as
per your
for my
clients.
clients, as for my clients.
This amount is due as per our calculation. Their calculation may be other, but we'll see to it.
Our calculation already done. Your lordship. Our calculation has already been done.
We
But
have
this-
to,
But they
no,
are.
I understand difficulties. I understand difficulties. Only what, some calculation has to be made by my client with a huge calculation. How many employees are there? At least a week time should be given so that calculation is made. Come up before this court and say that these are the calculation which we have made.
Next Thursday.
Next Thursday, no? Next Thursday. I'm deeply obliged. Obliged, your lordship.
Item 22 for hearing.
Present for me.
Item 23.
By earlier order, my lord, record was called for. Record from the revenue board.
Revenue appeal.
Yes, against the revenue appeal, my lord. This respondent has preferred the repetition, my lord. That was dismissed by the learned single judge, my lord, and this appeal, my lord.
Who is in possession of the land?
My lord, respondent.
Respondent. What do you want? Possession?
No, my lord, my case is that I have never leased out any leased, nor, my lord, I have.
No, but these are things the Board of Revenue cannot give a decisive opinion. These are all matters to be decided by the civil court.
That's why, my lord,
Go to
my
the
lord,
civil court.
revenue board has, my lord, directed the deputy commissioner. So, my lord, the deputy commissioner has some power, my lord. He can whether a document,
Power to?
my lord, whether a document is, my lord, forged or.
Absolutely not.
Yes. My lord.
There is no such power. Deputy Commissioner cannot decide all those things.
But, my
You
lord,
have a civil claim, you have to agitate it before the civil court.
but that is correct, my lord.
Go there. And
That's,
whatever is
my
the
lord,
decree,
learned single judge,
the
my lord,
revenue authorities will have to go by that.
my lord, learned single judge has given separate view, my lord.
Yes, Mr. Decker.
My lord, here the issue was whether they had transferred the annual patta land to me or not. Now, my lord, though they have disputed that particular sale deed, my lord, otherwise they've also admitted that they've sublet or leased the property to me. So based on that admission, my lord, the single judge has held there's been a contravention of the rules and therefore the land should become sarkari. Now, eventually, whether it's settled with me or not, that of course is the prerogative of the state, my lord. But so far as they are concerned, since they have divested of possession, my lord, their annual patta should go. That is the finding.
My lord, our case,
What is the order of the revenue board?
Revenue Board had held that the document that was put forth to suggest that they transferred it to me was an unregistered document, so that cannot be looked into. With that view, it was remanded to the Deputy Commissioner. Now the learned single judge has held,
First of all, how can an annual Patel land be transferred?
it cannot be transferred.
Then whether the document is genuine or
Precisely,
it doesn't make any difference.
my lord, precisely our point, my lord. So since there's a de facto transfer, my lord, as per the judgments, my lord, that will be binding on both of us. Now, whether the state chooses to settle it with me or not, it's a discretion of the state, my lord. But since they had violated that term of the lease, they are not entitled to a renewal of the annual patta. That was the limited question.
The annual Patel has not been renewed.
It has not been renewed. It has been made sarkari. It is against that they've come in, my lord, to the revenue board.
You don't have any right.
my lord, our case was that
Oh, Brian. Land has become sarkari, readable has become infractions. What else is there? You agitate your grievance before the appropriate court, that's all. You can't get any relief in respect of sarkari land. So you withdraw it to pursue if you have any civil right.
Can I read the operating question of the, my lord, the revenue board order, my lord? Page 47, my lord.
47.
Yes, lordship. Para 5, my lord. On perusal of the relevant records and report, it is seen that Makhuram Bhakat, father of the appellant, was the original annual patta holder of the land in question. Record also shows that the father of the appellant during his lifetime had handed over the land in question to the present appellant through a registered power of attorney dated 25/7/78. The unregistered sale deed submitted by the respondent number 3 before the circle officer Guwahati stating to be the sale deed executed by Mukharam Kumar Pattadar of the land in question in favor of the father of the respondent number 3, transferring the said land has been denied to the appellant, stating that the name of their father was Mukharam Bhakat and not Mukharam Kumar, and he did not sell the land to the father of the respondent number 3 by anyway during his lifetime. The appellant as well as the learned advocate for the appellant have contended that an unregistered sale deed is not admissible in the eye of law of the Transfer of Property Act in respect of transfer of a land. According to the Transfer of the Property Act, the sale or transfer of immovable property worth more than ₹100 must be registered, and as such, the present unregistered sale deed is stated to be executed by the father of the appellant in favor of the father of the respondent number 3 is not admissible in the eye of the law of the Transfer of Property Act in respect of the land in question. On the other hand, except the aforesaid unregistered sale deed, there is no any other evidence on record to show that land in question has been transferred by the father of the appellant to the father of the respondent number 3. As such, the impugn order passed by the learned Additional Deputy Commissioner Kamrup on the basis of an illegal recommendation of the circle officer Guwahati is not accordant of the provision of the Transfer of Property Act. Moreover, the impugn order has been passed by the learned Additional Deputy Commissioner without hearing the appellant. In view of the above legal position in hand, we have the opinion that further scrutiny and hearing by the court below are necessary for the proper adjudication of the matter before passing the impugn order by this learned Additional Deputy Commissioner Kamrup Metro. Hence, this is a fit case to remand the matter to the court below for disposal afresh as per law after hearing the parties and causing a necessary field verification examination of the relevant land record. Accordingly, the impugn order dated 18/7/2005 passed by the learned Additional Deputy Commissioner Kamrup in NR case number 1/so is hereby set aside, and the appeal is remanded to the Deputy Commissioner for disposal afresh as per law within 3 months of the date of the receipt of this order after hearing both the parties and causing necessary field verification and scrutiny of the relevant land record. So this is, my lord, the final order of the Revenue Board, my lord. So, my lord, apart from that, I have not been heard also there, my lord.
Where?
In the, my lord, Deputy Commissioner, before that appeal. In absence of.
So what remains here? The learned single judge has set aside the order of Revenue Board,
Lordship.
remanding in a matter of first decision. Whatever be the decision, it is not going to make any difference because the land has become sarkari. If you have any civil right, you have to agitate it before the civil court, that's all. Whether the additional deputy
My case
commissioner
was that,
decides
my lord,
this.
I have not leased out my lord or let out. I have given the rent.
Before the deputy commissioner, that you have not let out the land.
So my lordship may remand the matter, my lord,
No, it
as
is
per
already
board of
demanded, sir.
lord.
It is already demanded.
No, my lord, learned single judge had dismissed my lord. Learned single judge dismissed my lord. No, there is order of the my lord remanding back to the. My lord, that part was
Both
learned
parties will be at liberty to approach the civil court. That's all.
oblige, oblige your best.
Item 29.
May it please your lordship. My lord, there is a little background in this case. Let me indicate that. My lord, from 1979 to 1985, there was an agitation against presence of foreigners in the state. My lord, pursuant to that agitation, there it culminated into an accord, what we commonly call Assam Accord. Now, in Assam Accord, my lord, various provisions were made. Amongst others, my lord, one of the clause was that the victims of this agitation, they will be appropriately employed in the state government. And accordingly, my lord, a special rule was framed, which was given overriding effect over all the recruitment rules. Now, in terms of that rule, my lord, I was appointed. But what the authority did, my lord, instead of appointment me regularly, they appointed me initially on ad hoc basis. I continued uninterruptedly. Then I was regularized. Then I said my seniority should be counted from the day one. Now I approached this honorable court with a prayer that my regularization should be with effect from the initial date of appointment, not with effect from the date of regularization. That writ petition was dismissed. Subsequently, my lord, when the inter-se seniority list was, drawn, there I was aggrieved because assuming, my lord, my appointment is not antedated to the initial date, but in view of the proposition 2 of the direct recruit case, I'm entitled to the seniority. My lord, this honorable court remanded the matter to the department to dispose it of. They did not do, they decided against me.
In that writ petition. Or
In the second writ
second
petition,
writ petition.
yes.
Okay, and
Then
you
they
have
did
said
not decide, then I filed my third writ petition.
that is
In
pending.
third writ petition, my lord, since there was a difference of view between two departments, as per the Assam rules of executive business, this honorable court directed that this matter should be placed before the cabinet.
Okay.
Now, in doing so, my lord, that particular department which was against me, they, my lord, I'll present it. They have, my lord, projected thing in a totally different manner. Eventually, the cabinet decision was against me. Then I again approached in this round of litigation. The learned single judge has dismissed my writ petition. Why I am before your lordships. My lord, it's a very small point according to me, subject to lordship may say. If a lordship would kindly have this 1992 SCC 715. That direct recruits case, my lord. My lord, may kindly come to page 745. Paragraph 47, capital A, on top. Once an incumbent is appointed to a post, according to rule, his seniority has to be counted from the date of his appointment and not according to the date of his confirmation. The corollary of above rule is that where initial appointment is only ad hoc and not according to rules and made as a stopgap arrangement, the officiation in such post cannot be taken into account for considering the seniority. Now please come to B. If the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till regularization of his service in accordance with the rules, the period of officiating services will be counted. My lord, lordship knows in that West Bengal, state of West Bengal versus Ogornath Day, this B was explained. So I'd like to rely on that, my lord. That is 1993, 3 SCC 371. 1993, 3 SCC 371. My lord, may kindly come to page 382, para 25. So whatever, gray areas were there, those were set at rest. Yes. In our opinion, the conclusion B was added to cover a different kind of situation wherein the appointments are otherwise regular except for deficiency of certain procedural requirements laid down by the rules. This is clear from the opening words of the conclusion B, namely, if the initial appointment is not made by following the procedure laid down by the rules, and the later expression till regularization of his services in accordance with the rules, we read conclusion B, and it must be so read to reconcile with conclusion A to cover cases where initial appointment is made against existing vacancy, not limited to fixed period of time or purpose by appointment order itself, and is made subject to deficiency in the procedural requirement prescribed by the rules for adjudging suitability of the appointment for the post being cured at the time of regularization, the appointee being eligible and qualified in every manner of the regular appointment on the date of initial appointment in such cases. Decision about nature of the appointment for determining whether it falls in this category has to be made on the basis of the terms of the initial appointment itself and provision in the rule. In such cases, the deficiency in the procedural requirement laid down by the rule has to be cured at the first available opportunity without any default of the employee, and the appointee must continue in the post uninterruptedly till regularization of his service in accordance with the rules. In such cases, appointee is not to blame for the deficiency in the procedural requirement under the rules at the time of his initial appointment. An appointment not being limited to a fixed period of time is intended to be a regular appointment, subject to remaining procedural requirement and rules being fulfilled at the earliest. So, my lord, I continued it was not my fault that I was given an ad hoc appointment, and I continued the regularized, and I continue. Therefore, the question of denying seniority to me does not arise. I'm covered by paragraph B as explained in Ogornath Day. My lord, every time the matter is remanded, they will take it. And my lord, they feel that the appointment was made under a particular rule. That is not even the case.
Why the learned single judge has not suited you?
Learned single judge has non-suited me because in the first round of litigation, when my prayer for regularization was rejected, with effect from the initial date.
Therefore, now the question is no more reciprocal.
But that I sought regularization from the very first date. That is an issue not even required to be gone into. Assuming my appointment was not regularized, regular from the day one. But by virtue of my lord, my continuance and subsequent regularization, and that too, it was not my fault.
If the, once your request for regularizing your services from the initial day.
Yes.
Of your temporary appointment or whatever it will be, that
Yes.
has been rejected.
Yes.
You have not challenged that.
I challenged that.
Then in what happened that?
No, that writ petition was dismissed.
That writ petition,
Yes.
again, that dismissal you have not.
No, that was not carried in appeal. No,
Let's did appeal. Then subsequently, interest seniority, again, do you raise this question?
yes. Then High Court remanded the matter.
Maybe remanded the matter.
No, my
but
lord.
Ultimately.
No, my lord, thereafter, two orders are there.
High Court remanded the matter after observing this, that.
Yes,
though-
after noticing that there was a judgment. Kindly see, my lord, there are two, not only one, two judgments. Subsequently, it was said, now since two departments are different, personal departments, view is in my favor.
You have this second remand by the High Court, where is that?
Yes. Second remand, my lord.
Rather,
Yes.
First demand.
Page-
First remand.
First remand is at my lord, page number 80. Huh? No. 1 second, my lord. Page 66.
Yes.
The grievance raised in this writ petition is in respect of gradation list dated 23/12/2002. The petitioner's name appears as serial 418 in the said gradation list. According to the petitioner, his name ought to have been at serial 121 by giving appropriate interpretation of the rules framed under the Assam Public Service Preferential Appointment Rule 1986. This is the rule under which, my lord, my appointment ought to have been made, which was not made. Writ petition is pending for last 9 years. If the petitioner is still aggrieved by the said gradation list, it will be open for him to make a representation before the authority. In the event of making such a representation, said authority shall pass a speaking order dealing with the contentions that may be raised in the representation. Happy, sir? 88. 88. Your lordships kindly come to this second order, my lord, at page 88, the operative portion.
No, this, the first order.
Yes.
Whereby your prayer for regularization from the date of initial date, which is, where is that?
Okay, that order is in the affidavit file. 1 second, my lord. Page two kiman asile?
157.
157. Your lordships would kindly come to page 160. In the instant case, para 5.
Yes.
In the instant case, at no stage, that is either at the stage of ad hoc appointment or at the time of regularization, petitioner have been tested by a competitive examination. In the process, the ad hoc appointment of the petitioner continued for nearly 2 years. It was neither possible for the state authority to hold a special recruitment for the petitioner under the rules of 63, nor was it possible for the authority to put the clock back and asks petitioner to qualify themselves with others who may have already been selected under the rules of 1963. State government also considered it inequitable to do any to do with the service of do away with the service of the petitioners who were admittedly victim of events which entitled them to the benefits of the rules of 1986. Faced with such a situation,
Where is the third order?
yes, that your lordships will, the operative portion is at page 88. I have heard, has the lordship got it, my lord? Page 88.
Yes.
I have heard the counsel for the parties, and on perusal of the materials on record, I find that letter dated 2/2/15 issued by Department of Personnel ends with a proposal to place the matter regarding petitioner service before the cabinet. Thus, the question was to be decided by the cabinet as per decision recorded in letter dated 2/2/15 issued by the Personnel Department. However, without waiting for the cabinet decision, the Secretariat Administration Department has issued the order dated 25/8/15, which is not in synchronized with the letter dated 2/2/15 issued by the Personnel Department. At this stage, Mr. M. Khataniar, counsel for respondent number 1 and 2, and 4, that is state, my lord. H.K. Mohanto, counsel for the Personnel Department, and K. Chaudhary for the petition all agree that matters should be placed before the cabinet for its perusal and consideration decision as per proposal given by the Personnel Department in its letter dated 2/2/15. In that view of the matter, writ petition is disposed of with a direction to the Chief Secretary, Government of Assam, to place the letter dated 2/2/15 issued by Joint Secretary to the Government of Assam Personnel Department, along with letter dated 25/8/15 issued by the Commissioner and Secretary to the Government of Assam.
At two.
Well, my lord, I was placing the third judgment, my lord.
Yes, third case. 17/2/2016.
Yes, my lord, at page 88.
Yes.
I have heard the learned counsel for the parties, and on perusal of materials on record, I find that letter dated 2/2/2015 issued by Department of Personnel ends with a proposal to place the matter regarding petitioner service before the cabinet. Thus, the question was to be decided by the cabinet as per decision recorded in the letter dated 2/2/15 issued by the Personnel Department. However, without waiting for the cabinet decision, the Secretariat Administration Department had issued order dated 25/8/15, which is not in synchronized with the letter dated 2/2/15 issued by the Personnel Department. At this stage, Mr. Khataniar, counsel for the respondents 1, 2, and 4, H.K. Mohanto, counsel for the Personnel Department, and Sri So-and-so, learned senior counsel for the petition all agree that matter should be placed before the cabinet for its perusal and consideration as per the proposal given by the Personnel Department in its letter dated 2/2/15. In that view of the matter, its petition is disposed of with a direction to the Chief Secretary, Government of Assam, to place the letter dated so-and-so issued by the Personnel Department, along with letter dated 25/8/15 issued by the Secretary of Administration Department, to the additional filed by the petitioner and other connected documents before cabinet for its perusal and consideration decision in the next meeting.
What is the letter?
Yes.
2nd of February 2015.
Page 73, my lord. My lord, it's a long letter. If your lordship would kindly come to page 74. Please come to the sentence that the contents from 1 to 5.
Yes.
That the contention from 1 to 5 of the writ petitioners are found to be true. It is observed that the group of 26 incumbents were appointed under Assam Public Service Preferential Appointment Rule 86, framed under proviso to Article 309 of the Constitution, but were appointed on ad hoc basis, invoking the provisions of an OM issued by the Personnel Department, which has provision inimical to the provisions of the above rules of 86, and also unnecessarily relaxing a wrong rule, namely Rule 16 of the Assam Secretariat Subordinate Service Rule 63, dealing with the matter of appointment of UDS, not LDS. This relaxation was unnecessary as the said rule of 1986 had the overriding provision. Since an error was committed by giving ad hoc appointment to this incumbent under the rules of 86, they were regularized in the year 92, specifically mentioning that they will be placed below the assistant recruited in the year 92. No reason was cited for this deviation in regularization. Even if the fact that the applicant were appointed when there was an advertisement pending for recruitment of junior assistant who were finally recruited in 92 was the reason. This is perhaps not justified simply due to the fact that these newly recruited incumbents of 92 batch were not even born to the service when these 26 candidates had joined service in 1990. In this context, para 10 and 11 of the High Court's order is worth noting. According to Mr. Khatri, Learned Counsel for the petitioner, such deemed appointment to ACS Class 1 from ACS Class 2 cannot take away the accrued right of the petitioner, inasmuch as the petitioner had responded to the advertisement on 26/3/89, and the amendment was brought much later after 16/12. According to him, irrespective of his appointment to this service in 92, seniority will have to be determined in reference to the aforesaid advertisement. Apart from the fact that aforesaid plea of the petitioner had already gone into in the earlier round of litigation, the said plea is also not sustainable in law merely because petitioner had responded to the advertisement dated 26/3/89. No right had accrued to him. His name was empaneled pursuant to the selection conducted thereafter, and eventually he was appointed in 92. The fact of the matter is that by the time the petitioner was appointed in 92, private respondents came to be appointed to ACS Class 1 by virtue of the aforesaid amendment brought by notification dated so and so. Various judicial courts held that an OM office order, executive order cannot override the provisions of a set of rules framed under Article 309. The fact that the scheme of regularization cannot prevail over the rules has time again been pronounced by the Supreme Court in various cases, and Umadevi's case is one of the notable examples. Normally, statutory rules are framed under the authority of law governing employment. It is recognized that no government order, notification, or circular can be substituted for the statutory rules framed under the authority of law. This is because following any other course should be disastrous in as much as it will deprive the security of tenure and right of equality conferred on civil servants under the constitutional scheme. It may even amount to negating the accepted service jurisprudence. Therefore, when statutory rules are framed,
The matter accordingly following the due procedure be placed before the cabinet. Fine. Then
now what had happened, my lord? While placing matter before the cabinet, some mischiefs were committed, my lord. That I'll point out, my lord.
That
No,
you
no.
have challenged, that you have challenged.
Yes, that is under challenge.
Now,
Now, my lord,
no, the division, thereafter the decision was taken on 25th of August 2015,
yes,
which the learned single judge has negated by the order dated 16/2/2016,
yes,
and thereafter sent the matter for to the cabinet.
cabinet.
Now the cabinet.
Now, yes, I'm placing the cabinet memo, my lord. If your lordships will kindly permit me, please come to page 100, my lord. My lord, it starts from page 100 and it ends at page 105, and cabinet decision is at 106. But I will have your lordship's kind attention to page 103. Kindly see what was done. Views of the personnel department at page 103.
Yes.
And last two subpara. Therefore, the letter of personnel department dated 2/15, which was based on the views offered by the then Advocate General Assam and other order of the Secretariat Administration Department dated 25th of August 15, should have been the basic content of the memorandum. Other details are already in those letters. A comparative analysis, if incorporated in the memorandum, would have led to a better comprehension of the matter by the honorable members of the cabinet, as it is a technical complex matter. Even those are not even a part. The department may also sufficiently explain the position of the staff if the cabinet agrees to claim the claims of the petitioners giving seniority with effect from the date of their joining. In the case, the only solution to this long-standing issue is to create either the equivalent number of supernumerary posts or ex-cadre posts for the incumbents without hampering the seniority of others, because even in case if they are given seniority with effect from the date of their joining, they will not be able to get the designated position, as there are no such vacancies in the cadre immediately to accommodate them. In the link file of the department, so-and-so has unnecessarily raised the point about competency of the issue to be discussed in the cabinet, despite the fact that there's a High Court order and the order of the Chief Secretary. This is a serious matter and may be taken up with the Administrative Reforms and Training Department. Now kindly see the views of the administrative, my lord, third subpara. As such, since all other employees obtain under the said rules, it is regularized with effect from the date of the joining, they also deserve the same treatment. Similarly, SI department observed that they were not actually appointed under Assam Public Service Preferential Rule, hence they do not deserve regularization with effect from date of their joining. Since the views of the two departments differ, High Court has ordered to place the letter before the Honorable Cabinet along with the complaint letter of the officer for a decision. The above informatives may be removed from the Cabinet memorandum. Apart from the above, contents of para 2 regarding giving seniority to the applicants with effect from 25 to 90 is not correct, as the applicants have been given seniority only after 12/11/92, only after incumbent among 92 batch joined the last. In para 4, Judicial Department view on the order of the High Court is not in context, as already High Court's order dated 29/5/12 was in force in respect of the writ petition. The later case has not been mentioned anywhere. Now, every time what they do, my lord, they refer to the first order of the this honorable court of the single judge. That claim was rejected, therefore they propose the file. Now, my lord, the first order which was put to challenge in the second case, please have a look at that. That will cleanse the issue. Page 80, my lord. So I'll be squarely covered by that overnight this explanation. Page 80. This is the part of order dated 25/8/15, my lord, which was put to challenge in the third writ petition. The decision part, page 80. From the above discussion, it becomes clearly established that Sri Kolita was indeed appointed on ad hoc basis for a period of 2 months, initially on the basis of EO letter dated so and so. This is the OM, my lord, based on which I was appointed, and not in accordance with the rule. That this ad hoc appointment was extended from time to time is a fact borne out by record. That his services was later regularized by the government so moto in 92 along with others is also a fact in record. And that the period of ad hoc services cannot be counted for seniority over and above regular appointment is an established principle. This is not correct. The post having existed, now this is important, and the appointment having possessed the requisite qualification, the appointment do not appear to me to be illegal but irregular, inasmuch as they were not made by following the laid down procedure contained in Rule 8(1) of the 63 rule with preference accorded under the so-and-so rule. This necessitated the subsequent OM of Personnel Department dated so-and-so regularizing the ad hoc. That means, my lord, Secretariat Administrative Department's view is also that my appointment was irregular. If it is irregular, my lord, applying the principle laid down in overnight day, it can be corrected. My lord, is it my fault that instead of giving me a rule under that special rule, I was given an ad hoc appointment for 2 months and thereafter my appointment was extended from time to time. Now, my lord, learned single judge in this round, the latest round of litigation has gone by the first order. Assuming, my lord, in the first order, I was not given regularization from that date. That does not take away my right to claim seniority because of the second principle laid down in direct recruit's case. So that, in my humble submission, was wrongly decided by the learned single judge, my lord. If your lordship kindly comes to the impugned judgment, my lord will kindly come to page number 267. नहीं करा है तो नहीं दिया हाँ
Mr. Chaudhary, what my lord is indicating at, that assuming that the arguments you are making are liable to be considered on merit, the order passed in 2002 practically extinguishes your claim of seniority. That order has attained finality, neither any appeal nor any review petition has been filed. So we are on a purely technical count that once your claim is extinguished by an earlier order passed by the learned single judge, which has attained finality, viewed from any angle, can you revive that claim afresh?
My lord, my lord, my claim in that writ petition, which writ petition was dismissed, was that I should have been considered to be regularly appointed with effect from 1990. That plea was turned down. Now, I am not disputing that position, my lord. All right. But by virtue of the law laid down by the Honorable Supreme Court, am I not entitled to count my seniority from that date, though my regularization is not from that date? That is what the proposition B is, which has been explained in Oghornath Day. Kindly see, my lord, the Secretariat Administration Department at page 80, the passage which I read, there they clearly say that it was irregular, not illegal. Please come to my order, page 52, my lord. Page 50, 52, my first order of appointment.
Yes.
Subject to discharge without notice, without assigning any reason thereof, and under the provisions of Assam Public Service Preferential Appointment Rule 86, as amended, read with Rule 16 of this so-and-so, Dilip Kolita is hereby appointed on ad hoc basis. Where is the scope of making ad hoc appointment, my lord, when this rule is holding the field? They made my appointment under that page 50 OM, my lord. How can there be an OM?
Was this appointment against a regular vacancy?
Yes.
Where does one find it?
No, my lord, because I think it has been said by the government order itself. Please come to page 80, my lord. Page 80, the decision, first subpara. The post having existed and appointee having possessed the requisite qualification, appointment do not appear to me to be illegal but irregular. This order is helping me, my lord, in my humble submission. It's a regular post. That is why, my lord, in Ogornath, they say there were some procedural infirmities which the authorities should correct it at the earliest. But they did it. It's not-
The question is, the observation or the findings reported by the learned single judge in the year 2002.
Yes.
So these findings are the period of ad hoc services rendered by the petitioner from 29/190 was treated as contrary to the rules of 1996.
Yes.
How you overcome this? This is the judicial pronouncement. Even though the government or the officers of the government later on has said that, yes, the rule, your continuation as a ad hoc service was not irregular or was not in accordance, not in violation of the rules of 1996, but only irregular. Then also how to overcome by this observation, sir?
My
This
lord,
has attained
my
finality.
lord, my humble understanding is even learned single judge, while in 2002 has not said that my appointment is illegal. He says only irregular. And irregularity is the part
19 was treated as contrary to the rules of 1996.
being irregular. Being irregular. With your lordships, kindly allow me to place that Ogornath days one passage once, my lord. Perhaps I know it's a hard case, my lord. There's a judgment against me, and therefore, let me try to satisfy your lordships, my lord.
Yes,
Please have that judgment for a moment, my lord.
yes.
That I have placed it once. That 1993, 3 SCC 371. After this, I'll leave it to your lordships, my lord.
Para 25.
Please come to page 383, next page.
Yes.
Placitum B, my lord.
Yes.
In such cases, sentence above that, decision about nature of appointment for determining whether it falls in this category, that is B, has to be made on the basis of the terms of the initial appointment itself and provisions in the rule. In such cases, the deficiency in the procedural requirement laid down by the rule has to be cured at the first available opportunity without any default of the employee. An appointee must continue in the post uninterruptedly till regularization of his service in accordance with the rule. In such cases, appointee is not to blame for the deficiency in the procedural requirement under the rules at the time of his initial appointment, and the appointment not being limited to a fixed period of time is intended to be a regular appointment subject to remaining procedural requirement of the rules being fulfilled at the earliest. In such cases also, if there be any delay in curing the defects on the account of any fault of the appointee would not get the full benefit of the earlier period on account of his default. The default being confined only to the period for which he is not to blame. This category of cases different from those covered by corollary in conclusion A, which relates to appointment only on ad hoc basis as a stopgap arrangement and not according to rules. My appointment was as not a stopgap arrangement. There was an existing post. My lord, with all respect, I have a hurdle to overcome because of the judgment. But then it is not a case, my lord, where I think lordships will consider my prayer, my lord. I know it's a slightly, my lord. Therefore, my humble submission is, lordship will consider my case. I'm deeply obliged.
Only one thing I'd like to point out, my lord, before starting my argument. One clarification. In page 158, the first writ petition, my lord, all along statement has been made by the writ appellant that my
With the lordship's kind permission, can I take leave, my lord? My lord, friend would be there, my lord. Deeply obliged.
well, all along a statement has been made by the writ appellant that in the initial, my lord, first writ petition, it was moved claiming regularization. But that's not the fact, my lord. It's apparent from para 2 of this order. May I point out, my lord?
Yes.
Para 2, the entitlement of the writ petitioners to the benefit of seniority from the date of their appointment on ad hoc basis, that is 29/190, is the subject matter of the present writ application. It's not for regularization. And it has been turned down, my lord. It has been rejected. Now again, my lord, by this fourth writ petition, he has been reiterating the same, my lord, prayer. It is not for regularization. It was for, my lord, interstate seniority from the date of the ad hoc appointment. It has been recorded, my lord, in the very first para, in second para, my lord. So to say that we approach for regularization, that's not a correct fact, my lord, from apparently, my lord, from this order. Now, my lord, if a prayer made by the petitioner has already been rejected by honorable court, whether the cabinet, my lord, can bypassing this order, grant him that benefit, my lord.
Cabinet, in fact, not.
No, that's why I'm saying, my lord, what they are trying to say is that the cabinet has been moved. And that apart, my lord, this judgment, my lord, that has been relied upon regarding, my lord, that point number B. May I read it only one point, my lord? One line. It is, my lord, page 382, the third line from, my lord, below. We read conclusion B and it must be so read to reconcile with conclusion A to cover the cases where the initial appointment is made against an existing vacancy. My lord, this point is relevant, not limited to a fixed period of time. Lordship will see the appointment engagement letter at page 52. It was for 2 months.
Where you are reading?
My lord, the last third line in page 382.
Para number 25 only.
Yes, my lord, para
Yes.
25.
We read
Conclusion B and it must be so read to reconcile with conclusion A to cover the cases where the initial appointment is made against existing vacancy, not limited to a fixed period of time. I pause, my lord. Page 52, Lordship may kindly peruse the initial engagement. It was for 2 months.
Page
52 of the appeal memo. Page 52, first para, last second line. As admissible for a period of 2 months with effect from the date of joining.
subject to the discharge or without notice assigning any reason thereof or provisions of rule 16 so and so, hereby appointed on a paid basis as a lower division assistant some technical phase.
There were 22 in total in
No,
that
my lord,
category.
26 or 27 was there. In fact, it has been reflected in the Learned Single Judge's order, my lord.
And what happened
26.
to the, all those
All those were regularized along with the petitioner from the.
1992?
92, my lord.
None has raised any
No,
objection.
no, man. Only once they came in the first writ petition, 4 came before the honorable court. Thereafter, it is the writ petitioner who has been pursuing. They have ultimately both done.
And in this 2002 order,
My lord,
the present petitioner was also one of the writ petitioners.
yes. One of the writ petitioner. And in fact, my lord, the rule of 1986 says that, my lord, under that particular rule, a certificate will be issued to those persons who have.
In the first writ petition, all 27 persons have filed writ petition.
My lord.
Including the petitioner was the
No,
main.
yes, 27, my lord.
27.
27.
Judgment reserved. Argument sought, judgment reserved.
Obliged, my lord.
Judgments की photocopy. Copy your pairs. Let's say